Chapter 4. Administrative Lawlessness. It is not, but it ought to be, common knowledge that there is in this country a considerable number of statutes, most of them passed during the last 20 years, which have vested in public officials, to the exclusion of the jurisdiction of the courts of law, the power of deciding questions of a judicial nature. Usually the power is given nominally to the minister or other head of a government department, sometimes to the department itself, and it is commonly provided that his or its decision shall be final and conclusive. When it is provided that the matter is to be decided by the minister, the provision really means that it is to be decided by some official of more or less standing in the department, who has no responsibility except to his official superiors. The minister himself, in too many cases, it is to be feared, does not hear of the matter or the decision, unless he finds it necessary to make inquiries in consequence of some question in Parliament. The official who comes to the decision is anonymous, and, so far as interested parties in the public are concerned, is unascertainable. He is not bound by any particular course of procedure, unless a course of procedure is prescribed by the department, nor is he bound by any rules of evidence, and indeed he is not obliged to receive any evidence at all before coming to a conclusion. If he does admit evidence, he may wholly disregard it without diminishing the validity of his decision. There is not, except in comparatively few cases, any oral hearing, so that there is no opportunity to test by cross-examination such evidence as may be received, nor for the parties to controvert or comment on the case put forward by their opponents. It is, apparently, quite unusual for interested parties even to be permitted to have an interview with anyone in the department. When there is any oral hearing, the public and the press are invariably excluded. Finally, it is not usual for the official to give any reasons for his decision. To employ the terms administrative law and administrative justice to such a system, or negation of system, is really grotesque. The exercise of arbitrary power is neither law nor justice, administrative or at all. The very conception of law is a conception of something involving the application of known rules and principles, and a regular course of procedure. There are no rules or principles which can be said to be rules or principles of this astonishing variety of administrative law, nor is there any regular course of procedure for its application. It is possible, no doubt, that the public official who decides questions in pursuance of the powers given to his department does act, or persuades himself that he acts, on some general rules or principles, but if so, they are entirely unknown to anybody outside the department, and of what value is a so-called law of which nobody has any knowledge? The idea of justice contemplates at least an independent and impartial judge, who founds his judgment on evidence and reason. By provision of the Act of Settlement, the judges hold office during good behaviour, instead of, as before, at the pleasure of the Crown, and they can be removed only on an address to the Crown by both Houses of Parliament. They are, therefore, practically irremovable, and it may be observed that their salaries, being charged on the consolidated fund, do not appear in the annual votes. Moreover, by parliamentary practice, it is not permitted to comment on the conduct of a judge except on a formal resolution for an address to the Crown for his removal. The system of so-called administrative law in this country has little or no analogy to the droit administratif of the continent, and is an indescribably more objectionable method. The droit administratif is administered by real tribunals known to the parties, and these tribunals apply definite rules and principles to the decision of disputes, and follow a regular course of procedure, though the rules and principles applied are different from those of the ordinary law governing the relations of private citizens as between themselves. Moreover, the tribunals give reasons for their decisions and publish them. In a word, the administrative tribunals of the continent are real courts, and what they administer is law, though a different law from the ordinary law. More than that, the droit administratif is a regular system of law, applicable not only to all matters pertaining to the public service, but also to all disputes between the government or its servants on the one hand, and private citizens on the other hand. Administrative law in this country is not really a system at all, but is simply an exercise of arbitrary power in relation to certain matters which are specified or indicated by statute, not on any definite principle, but haphazard, on the theory, presumably, that such matters are better kept outside the control of the courts and left to the uncontrolled discretion of the executive and its servants. The public official is not independent. As a civil servant, he is liable to be dismissed at any time without notice and without any enforceable right to compensation. One would have thought it perfectly obvious that no one employed in an administrative capacity ought to be entrusted with judicial duties in matters connected with his administrative duties. The respective duties are incompatible. It is difficult to expect in such circumstances that he should perform the judicial duties impartially. Although he acts in good faith and does his best to come to a right decision, he cannot help bringing what may be called an official or departmental mind, which is a very different thing from a judicial mind, as everybody who has had any dealings with public officials knows, to bear on the matter he has to decide. More than that, it is his duty as an official to obey any instructions given him by his superiors, and, in the absence of special instructions, to further what he knows to be the policy of his department. His position makes it probable that he should be subject to political influences. Let it be supposed, for the sake of the argument, that the power of deciding disputes as to liability to income tax were vested in the Board of Inland Revenue, without appeal to the courts. Could it be suggested that the subject would be likely to receive judicial treatment? Oh, it may be said, but that is an extreme case which would never be sanctioned by Parliament. Yet it would not be different in principle from the case exhibited by the powers vested in the Minister of Health in relation to national insurance. It is the decision of his delegates which is final and inconclusive, both in fact and in law, as to the rates of contribution payable by or in respect of insured persons, and his findings of fact are conclusive on any question whether any employment or class of employment falls within the scope of the Act, a question which, of course, determines the liability to pay contributions. Will anybody at this time of day deny that it is essential to the proper administration of justice that the decision should be based on evidence, and that the evidence should be heard in the presence of both parties, who are given the opportunity of cross-examination? Evidence not tested by cross-examination is nearly always misleading and practically valueless. The public official, as has been observed, may, and often does, decide without any evidence at all, and he may act on ex parte statements made by one party without anything to support them, which are never brought to the knowledge of the other party, so that he has no opportunity to controvert them. Is it too much to say that such proceedings are a mere travesty of justice? It is also essential to the proper administration of justice that every party should have an opportunity of being heard, so that he may put forward his own views and support them by argument, and answer the views put forward by his opponent. More than that, it is of great importance that all judicial proceedings should be held in public, so that the public may know what is being done, and be able to judge whether it is really justice or injustice that is being administered, and also have a guide to their own conduct. The departmental policy of secrecy, which is inveterate, is in itself sufficient to condemn the system under which the public departments act as tribunals to decide disputes of a judicial nature. This secrecy naturally leads to the conclusion that the departments are afraid of their proceedings being made public, and tends to destroy confidence in the fairness of their decisions. How is it to be expected that a party against whom a decision has been given in a hole and corner fashion, and without any grounds being specified, should believe that he has had justice? Even the party in whose favour a dispute is decided must, in such circumstances, be tempted to look upon the result as a mere piece of luck. Save in one or two instances, none of the departments publishes any reports of its proceedings, or the reasons for its decisions, and as the proceedings themselves, if any, are invariably held in secret, even interested parties have no means of acquiring any knowledge of what has taken place, or what course the department is likely to take in future cases of the same kind that may come before it. A departmental tribunal is, however, in no way bound, as a court of law is, to act in conformity with previous decisions, and this fact is commonly regarded as one of the reasons for the policy of secrecy. Others may think that the department is afraid to disclose inconsistencies and a want of principle in its decisions. However that may be, the policy is fatal to the placing of any reliance on the impartiality and good faith of the tribunal. It is a queer sort of justice that will not bear the light of publicity. In the kind of legislation which is being considered, it is usual to provide that the decision of the minister shall be final and conclusive. When this is the case, the courts are powerless to intervene, however unjust and absurd a decision may appear to be, and even though it is obviously based on an erroneous view of the law. It may be said that, if it can be shown that no real discretion was exercised by the deciding official, and the decision is merely capricious, or is perverse or corrupt, the courts might hold it void on the ground that it does not really constitute an exercise of the authority vested in the minister at all. But where one is dealing with a decision given without reasons, by an anonymous official, who is not ascertainable, how can any such matter be proved? How can it be shown that such a person, who has not disclosed the evidence, if any, on which he purported to act, was prompted by any particular motives? How can it be determined whether he has acted in good or bad faith, when he has not stated the reasons for his decision? It may be that the decision is apparently so perverse that the party against whom it is given has a reasonable suspicion that it was dictated by spite or vindictiveness, or was even corrupt. But, without knowing who the deciding official is, it is of course impossible for a person aggrieved to prove anything of the kind, or even to furnish grounds for suspecting it. The victim is, in such a case, perfectly helpless and entirely without remedy. He is completely at the mercy of a person who, for all he knows, may be a bureaucratic tyrant. If he did attempt to challenge the decision by proceedings in a court of law, he might well be told by the court that it must be presumed that the minister acted in good faith, and in such circumstances the presumption is irrebuttable. It may be said that there is no substantial ground for the fear of unfairness or corruption in the civil service. As to unfairness, people who have had disputes with public officials may sometimes conceivably hold a contrary opinion. As to corruption, that is a vice from which the service is completely and undoubtedly free. It is of vital importance that it should so continue. But if there were any great extension of the system of giving uncontrolled and arbitrary powers to public officials, it is as certain as that night follows day that corruption might creep in. We might then be cursed with the corrupt bureaucrat, the bureaucratic despot we already have. To take a simple instance, the treatment of the panel doctors under the National Health Insurance Acts is pure despotism. The doctors are liable, at the mere discretion of the official who acts for the Ministry of Health, to be ruined professionally by being struck off the panel, or, as a lesser punishment, to be fined to an arbitrary extent. In one instance, a fine of £1,000 was imposed on 2 doctors who carried on business in partnership. Excessive prescribing, an offence wholly unknown to the law, which consists in prescribing for the patient medicines that are either too expensive in quality or too liberal in quantity, is one of the things for which a doctor may be penalised. One might think that, for a person who is bound by law to insure and pay contributions under the Acts, the best medicine ought to be prescribed in illness, but apparently that is not always the view of the department. One might wonder whether, in this matter, the interests of the patients are adequately taken into consideration.